Hello. This is the second video about international contracts in international commerce law. Tomorrow we are going to have a meeting through Teams. I have already shared with you the link with the link for this meeting. Then we are going to comment the practical exercise you have done during this week and the two videos we have about international contract law. Next week, as I have explained to you, we are going to have a session with Professor José María de Dios, so we are not going to have a new video this week. We are going to have a full session next Tuesday, 19 May, and during this session, Professor José María de Dios and myself, we are going to explain insolvency. Now we are going to continue with international contracts. We have seen the main main introductory issues about international contracts, and we have started with the part of jurisdiction, considering Brussels 1 bis regulation. And we have seen the general rule about jurisdiction in the regulation, the relationship between Article 4 and Article 6 that you already know, and we have started with Article 25, the choice of court agreement. We have explained the substantial requirements of Article 25. That means that it's necessary to apply Article 25 that the court chosen is a court in a member state of the European Union, and other substantial issues related with this prorogation of jurisdiction, this choice of court agreement. But we haven't considered till now the formal requirements of the agreement. And this is a very important point. The choice of court agreement not must be in accordance with some formal requirements. The agreement is in Article 25, should be done in writing or evidenced in writing, and now we are going to see what that means. In a form which accords with practices which the parties have established within themselves, or in international trade or commerce in a form which accords with a usage of which the parties are or ought to have been aware, and which in such trade or commerce is widely known to and regularly observed by parties to contracts of the type involved in the particular trade or commerce concern. This is maybe a little bit strange, but we are going also to explain that. In writing, well, this is very easy because it's the case in which we have a writing document, and in this document we can find the signatures or both parties. This is a way, and as the Article 25 explains, any communication by electronic means which provides a durable record of the agreement shall be equivalent to writing. So that means that we can have a document in paper with the signatures of both parties, or we can have an interchange of emails, and this is also a writing agreement. If it's a communication but by electronic means, but with a durable record of the agreement, as can be an interchange of emails, then we are in the case of a writing agreement also. This is for sure the easiest way to introduce an agreement on the courts according with Article 25 of the regulation. But it can be also evidence in writing. What does mean? This implies that the agreement was not made in writing, what was made in an oral way, but one of the parties has written the agreement and can provide this document containing the agreement. But is a document provided by only one of the parties, because when we are facing a document with the signature of the both parties, then we are in an agreement in writing. When we are considering an agreement evidence in writing, is a different thing. The difference is that in an agreement evidence in writing, there is no writing agreement of both parties. There is only a document produced by one of the parties, but that it's a consequence of a previous oral agreement between the parties. And of course here the problem is the proof, because as we have on a document provided by only one of the parties, the other party can say that that party doesn't agree with the prorogation of jurisdiction, then there is no previous oral agreement between the parties, and in that case, if the other party cannot prove that there was a previous oral agreement, then the evidence in writing is not enough. You need to prove not only that there is a document provided by one of the parties, but that there is also a previous agreement between the parties. And this is the form evidence in writing. That sometimes there are cases about this situation, because it's not very unusual that one of the parties send to the other party the conditions of the agreement, including a choice of court agreement, and the other party simply doesn't say that this is not correct. But this is not an acceptance of the document sent by the other party. But this happens in the commerce and international commerce. If you want, we can comment that tomorrow in the meeting through Teams. But now it's important to realize the difference between writing and evidence in writing. I repeat, writing means with the signature of both parties or an interchange of emails between the parties. Evidence in writing means that there is a previous agreement, not document in paper or by electronic means, but there is an agreement between the parties, and there is a document including this agreement, but this document is provided by only one of the parties. It's a document made by only one of the parties. This is the difference between writing or evidence in writing. I hope that this is clear, but we can comment that tomorrow. And second possible form, in a form which accords with practice which the parties have established between themselves. That means that we cannot give general rules about this possibility, because it depends on the practice between the parties. The parties or the party interested in should prove that there is a certain way of doing things between the parties, and that the agreement was in the framework of this this way of relationship between the parties. So it's a question of, it's a problem of proof by one of the parties that there is a costume, there is some uses that parties practice between them, and that the agreement, the choice of core agreement, enters within these uses of the parties that have been practiced previously to the agreement. So there is no possibility of doing a general rule about that. It's a question of proof of the practices between the parties. This is the second way. The third way, in international trade of commerce in a form which accords with the uses of which the parties are or ought to have been aware, and which in such trade or commerce is widely known to and regularly observed by parties to contracts of the type involved in the particular trade or commerce concerned. What are they talking about in this paragraph C of Article 25.1? Well, in fact, this is a case that is intended to cover one particular document, the Bill of Lading. The Bill of Lading is a very important document in the international carriage of goods by sea, and it's a document provided by the carrier of the goods, the person who assumes the task to take the goods in one port and bring the goods to another country. And this document is a document in which the goods including the carriage are detailed, and this document includes also the conditions of the transport of the goods. And between these conditions, usually there is a clause, a contract term, about the jurisdiction, the courts with jurisdiction in the case, or an arbitration clause. So within the conditions included in the document Bill of Lading, usually there is a specific clause about jurisdiction. And this document, as I have explained, is provided by the person who assumes the transport, the carriage of the goods. And this document is not signed by the person giving the goods, the seller of the goods, or any other person, the person who is going to receive the goods at the end of the transport. Is a document provided only by one of the parties, the party who assumes the task to transport the goods from one point to another. So it's not a prorogation, a choice of court agreement within a Bill of Lading is not an agreement in writing, because there is only one signature, the signature of the person who assumes the transport of the goods. The other part in the contract is not signing, is not giving an express acceptance of the contract in the contract. The other part simply accepts the paper, accepts the document, but there is no signature of this part in the document. So it's not an agreement in writing. But neither is an agreement evidence in writing, because there is no previous oral agreement between the parties. Simply the person who gives the goods to the person who is going to transport these goods accepts the document provided by the carrier, the person in charge of the ship in some occasions, or the agent of the person who accepts to take the goods, to transport the goods in another cases. But the other part, the only thing he or she does is to accept this document. So it's not an agreement in writing, it's not an agreement evidence in writing. So what happens with this kind of agreements? That there are no valid, there are no effect, there has no effectivity under Article 25 of the Brussels 1bis regulation. This is not possible. I have to say that at the beginning, in the Brussels Convention of 1968, this was the situation. In the Brussels Convention of 1968, there was no provision equivalent to this Article 25(1)(c). The only ways of the only formal ways for an agreement on the jurisdiction of the court were the writing or evidence in writing, or according with the practice between the parties. So there was no provision about this agreement according with usuals of the international commerce, and then started the doubt. Somebody raised up the doubt about the validity of the choice of core agreements in bill of ladings. And this was a serious problem, because the carriers said very clearly that these kind of clauses were paramount for them, because they cannot assume the cost of litigating in any country in the world where they have business. They need, the carriers, they need to concentrate the disputes in one single core or two single cores, but they need to concentrate the litigation in a limited number of countries. And for this concentration of the litigation, these clauses of election of jurisdiction were essential. So it was also very important to allow the validity of this kind of clauses. And this was the reason that in 1988 it was introduced in the Brussels Convention, this provision about the uses of commerce. Thinking, the provision was thought to cover the bill of lading clauses. So nowadays, a clause included in a bill of lading will be effective because it's assumed that the acceptance of the bill of lading implies the acceptance of all the conditions included in the bill of lading. So when a person intends to act on the basis of a bill of lading, then this person is assuming all the conditions in the bill of lading, including the choice of court. So following this reasoning, the choice of court agreement included in bill of lading will be covered by this Article 25.1.c of the Brussels 1bis regulation. I hope that this is also clear. If you have any doubt, tomorrow we can discuss that. And then Another limitations related with Article 25. Agreement cannot be against the rules, the exclusive grounds of jurisdiction of Article 24. We are talking about Article 25.4 of the regulation, and that here it's established that the choice of core agreements cannot be against the exclusive grounds of jurisdiction in Article 24, and this choice of core agreements cannot be in against the provisions in Articles 15, 19, and 23. These provisions are related with the protection of weak parties. Protection of weak parties, we are talking about insurance contracts, Article 15, consumer contracts, Article 19, and individual contract of employment, Article 23. In these three cases, the Brussels 1B regulation assumes that there is a weak party that must be protected. And one, of course, the weak party is the consumer, is the worker in the individual contracts of employment, and is the person who is the policyholder in an insurance contract, or the beneficiary in an insurance contract, or the victim in some kinds of insurance contract. These are the weak parties: consumer, workers, and policyholder, insured, beneficiaries, victims in the case of insurance contract. And there are some rules about the protection of these weak parties. We are not going to enter into these rules here, but it's important to know that one of the ways of protecting these weak parties is not to allow in all cases choice of court agreements. And what Article 25.4 establishes is that the choice of core agreements that are against the provisions in relation with weak parties, insurance contract, consumer contract, individual employment contracts, are not going to be effective. So they are not going to have legal force. This is another very important limitation in the choice of core agreements. The choice of core agreements cannot be against the exclusive grounds of jurisdiction of Article 24, and they cannot be, again, the provisions about weak parties in insurance contract, consumer contracts, and individual employment contracts. I hope that this is also clear. We can comment that tomorrow. So we have seen Article 25. We should consider also Article 26, because Article 26 is covering another ground of jurisdiction based on the defendant's appearance before the court. The idea is that we have a court that has no jurisdiction according with the Brussels 1bis regulation. And the plaintiff introduces the claim before that court, and the defendant enters an appearance before the court. And this appearance of the defendant is not limited to contest jurisdiction. That means when the appearance of the defendant is aimed to contest jurisdiction, to say to the court, you don't have jurisdiction, I want that, my petition is that you dismiss your jurisdiction, you declare that you don't have jurisdiction for this case. When the appearance is in this sense, there is no competence of the ground of the court, but But when we are not in this situation, when we are in a court that has no jurisdiction, the claimant, the plaintiff, introduces the claim and the defendant enters an appearance, and that appearance is not for contesting jurisdiction. In that case, that court that initially didn't have jurisdiction assumes jurisdiction. It's called, it's not very correct, but we are not going to enter into that now. The court becomes competent because of the tacit submission of the defendant. This is the idea, tacit submission of the defendant. The defendant, with her behavior, is giving the measures that he or she is accepting the jurisdiction of the court. It's in some way an agreement on the court, but there is no an express agreement, but a tacit agreement. This is not completely true, but I don't want to enter now in this distinction. If you want, we can also comment that tomorrow through our meeting. But before, if you are not deeply interested in that, you can get this explanation that when the defendant enters an appearance, and I repeat, it's very important, the appearance is not for contesting the jurisdiction, then we understand that there is a kind of agreement between the plaintiff and the defendant in order to give jurisdiction to that courts. And that implies that these courts become competent. Article 26.1 of the Brussels 1 bis regulation. Apart from jurisdiction derived from other provisions of this regulation, a court of a member state before which a defendant enters an appearance shall have jurisdiction. This rule shall not apply where appearance was entered to contest the jurisdiction or where another court has exclusive jurisdiction by virtue of Article 24. This last point is very important. This ground of jurisdiction of Article 26 works in all topics, all matters of the regulation, but exclusive jurisdiction of Article 24. So, in cases in which we are before an exclusive ground of jurisdiction of Article 24, this ground of jurisdiction of Article 26 is not going to work, it's not going to apply. But outside these exclusive grounds of jurisdiction, then there is the possibility that a court without jurisdiction, according with other provisions of the regulation, will become competent according with this Article 26.1. The plaintiff introduces the claim and the defendant enters an appearance before the court. I hope that this is also clear. And this applies also when there is a choice of court agreement. So Article 26 prevails over Article 25. I hope that this is also clear. If you have any doubt, I repeat, we can study that tomorrow. And this is all. To summarize what we have said till now about jurisdiction, we have a general rule, Article 4 and 6. Article 6, when the defendant is domiciled in a non-member state. Article 4, when a defendant is domiciled in a member state. And as I have explained last week, not in the video, but in the meeting through Teams, and you have also the meeting through Teams in the Campus Virtual, in the Moodle, so you can watch it again. I have explained that when the defendant's domicile is in a member state, then the plaintiff can choose between introducing the claim before the courts of the defendant's domicile courts or before the courts designated by Article 7. And if we are talking about contracts, Article 7.1. 7.1. I'm not going to repeat now Article 7.1 because we have explained that article in the meeting of last Tuesday. So if you watch at the meeting in last Tuesday, then you will find an explanation about Article 7.1 of the Brussels 1B regulation. Now, I'm only remembering you that Article 7.1 applies alongside with Article 4. So you can use, the plaintiff can use Article 4 and introduce the claim before the courts of the defendant's domicile, the country of the defendant's domicile, or Article 7.1. And when this plaintiff uses Article 7.1, then the defendant can be sued before another court in another member state. Remember that very important point, that the Article 7.1 only, and Article 7 in general, only applies when the ground of jurisdiction determined by Article 7 is not in the country of the defendant's domicile. When Article 7.1 lets us to the country of the defendant's domicile, Article 7.1 and 7.2, Article 7 in general, doesn't apply. I hope that this is clear. So Article 4 and 7. The plaintiff has an option between these two articles. And when the defendant is domiciled in a non-member state, Article 6, and as you know, the court will determine its jurisdiction according with the domestic law of that member state. I hope that this is clear. And this is the general rule, and when there is a choice of court agreement, Article 25, this choice of court agreement prevails over these two rules, Article 4, Article 7, Article 6, Article 4, Article 7, and Article 6, yes, that's correct. And there is also the possibility of Article 26. That means that a tacit submission of the defendant, and this tacit submission prevails over Article 25. So Article 26 prevails over Article 25, and Article 25 prevails over the combination of Articles 4, 6, and 7. I hope that this is clear. We can discuss that tomorrow, if you want. Well, and this is the end. This is the end of the questions of jurisdiction. So we now are entering into applicable law. So till now we have been considering which court has jurisdiction in matters relating with contracts in international commerce. Now we assume that this question of jurisdiction is already done. We have resolved already the doubts about which are the competent courts, and the plaintiff has already introduced the claim. When this happens, the court that has to give a decision on the merits should determine the law governing the contract. And in each country, the court is going to determine this law governing the contract according with the conflict rules in force in that state. That means when the competent court is a Spanish court, the Spanish court is going to determine the law governing the contract according with the Spanish conflict rules, or being more precise, according with the conflict rules in force in Spain. When the dispute is before a Mexican court, the Mexican court is going to determine the law governing the contract according with the conflict rules in force in Mexico. If we are before a court in New York, in the United States, then that court is going to determine the law governing the contract according with the conflict rules in force in New York. I'm saying New York and not the United States because in the United States there are no federal conflict rules. The conflict rules are state rules. There are different systems of private international law in New York, New Jersey, Florida, California, Utah, Mississippi, and so on. The conflict rules are always state rules, not federal rules in the United States. So, before each court, we are going to determine the applicable law to the contract according with the conflict rules in force in that country, in the country of the court. We cannot consider all the courts of the world, of the conflict rules in force in all the countries of the world. So we are going to consider the law in force in Spain. That is also the conflict rules in force in all the European Union member states but Denmark. Denmark doesn't apply, but in the rest of the member states of the European Union, the conflict rule is the Rome 1 regulation. Regulation 593 2008 on the law applicable to contractual obligations, Rome 1 regulation. Then we are going to consider which is the applicable law governing the contract according with the Rome 1 regulation. Well, according with the Rome 1 regulation, the first rule is the freedom of choice. That is in Article 3 of the regulation. A contract shall be governed by the law chosen by the parties. So the parties have the freedom to determine the law governing the contract, and they can choose any law in the world. I mean, and this is a common mistake. The parties cannot only choose the law of a member state of the European Union. They can choose the law of any state in the world. According with Article 3, parties can choose the law of Spain, of Italy, of Germany, but also the law of Switzerland or the United States or India or Brazil, whatever they want. This is important, and remind that when we were talking about jurisdiction, Article 25 of the Brussels 1bis regulation, we have explained that the choice of court agreement should be made in favor of a court in a member state. So in that case, when we are talking about jurisdiction, the election should be made in favor of a court in a member state. But when we are talking about applicable law, then we can choose the law of any country in the world, not necessarily the law of a member state of the European Union. This is because the Rome 1 regulation is a regulation with what is called universal application, Article 2 of the Rome 1 regulation. Any law specified by this regulation shall be applied whether or not is the law of a member state. This is in Article 2 of the Rome 1 regulation, and that implies that parties are free to choose the law of any country in the world. I hope that this is clear. We can use Rome 1 regulation to choose the law of China, of Japan, of Australia, of whatever. Is that clear? If you have any doubt, I repeat, tomorrow we can comment that. And one other point, important point, is that parties can choose, as I have explained, the law of any country in the world, but the law of one country. It's not possible to choose, for example, lex mercatoria as law governing the contract, or the law of a continent, the European law, for example. This is not possible. This kind of choice will be not valid. The choice of the law of a country, the law of a state. This is the content of Article 3 of the Rome 1 regulation. Any country but a country. And this is important because in some cases the parties opted to choose, for example, lex mercatoria. This contract is governed by lex mercatoria. Well, this is not a choice of law in the sense of Article 3, so at the end the conclusion is that there is no choice of law in the contract, and then the contract is governed by the law determined by another rules of the regulations, rules that we are going to consider now, after the freedom of choice that is the first rule in the Rome 1 regulation. So the first rule, the first connection is the freedom of choice, the choice made by the parties. Article 3.1 explains that the choice shall be made expressly or clearly demonstrated by the terms of the contract or the circumstances of the case. That means that the easiest way to choose the law governing the contract is to introduce in the contract a contract term in that sense, a clause in the contract establishing that, for example, this contract is governed by the law of England. This is the easiest way to introduce that. But in some cases there is no specific choice of law clause, but if you consider the contract, it's clear that the parties wanted that the law of a specific country should govern the contract, because there are references in the contract terms to the law of that country, or the general presentation of the contract, the articulation of the contract is made according with the way in that law. If that is clear and should be clear, it cannot be something speculative, should be clear. If that is clear that the parties wanted that the law of a country will govern the contract, then we can understand, we can assume that there is a choice of law in the contract. But I repeat, the easiest way to introduce a choice of law clause in the contract is to introduce really a choice of law in the contract related with the law governing the contract. There are more issues about that, but I'm going to refer only to one issue that it could be important in the practice. That is the case in which the case in which the contract has connections only with one country and the parties choose the law of another country as law governing the contract. This is there are provisions about that situation in Article 3.3 of the Wrong One regulation, where all other elements relevant to the situation at the time of the choice are located in a country other than the country whose law has been chosen. The choice of the parties shall not prejudice the application of provisions of the law of that other country which cannot be derogated from by agreement. What does this mean? Well, first imagine the situation. The situation is, for example, a contract that is connected in all the relevant elements, for example, with Spain. The parties are companies incorporated in Spain and with main administration and principal place of business in Spain, and the contract is going to be performed in Spain, and there are no relevant connections with any other country than Spain. But in that contract, parties introduce a choice of law clause in favor of the law of Italy, for example. Well, what is saying to us Article 3.3 is that in that case, the law governing the contract is the Italian law. Although there is no not only connections with Italian law, that is not necessary. You can choose, as I have explained, any law in the world for ruling a contract. But although there are no relevant elements of the contract connecting that contract with other country than Spain, is a domestic contract in Spain, but although there is a domestic contract in Spain, parties have decided to introduce a choice of law agreement in favor of the Italian law. So the Italian law is the law governing the contract. There is no discussion about that according with Article 3.3 of the Wrong One Revolution. But the important point is that the application of Italian law doesn't prevent the application of the Spanish mandatory rules. That is, mandatory rules is what in the Article 3.3 is referred as provisions of the law which cannot be derogated from by agreement. These provisions that cannot be derogated by an agreement are, we are going to say, mandatory rules. Mandatory rules in the sense of civil law. You know, when you are writing a contract, when you are discussing and negotiating a contract, the parties can introduce all the contract terms they want, but these contract terms cannot be against mandatory rules. Mandatory rules in the sense that rules that cannot be derogated by the agreement of the parties. In each law, there are mandatory rules that are compulsory and that parties cannot derogate by the agreement. So, what it's explaining to us, Article 3.3, is that in that cases in which we have a pure domestic contract connected in all the relevant elements with one country, and the parties decide to determine that the law governing the contract is another one, this other law cannot prevent the application of the mandatory rules of the law of the country of the country whose that presents all the relevant elements connected with the contract. Again, the election of a law different than the law that the law of that of the country which the country in which is the contract connected in all the elements. The election of that other law, that foreign law, doesn't prevent the application of the mandatory rules of that law, the law of the country in which with which the contract presents all the elements. This is the idea. In that case, in a country that is connected in all the elements with Spain, but with a choice of law in favor of the Italian law is going to rule the contract, but the mandatory provision of the Spanish law are going to be applied. And this is the important point, because when in an international contract, a real international contract, imagine a contract that is connected with Spain, with Italy, with France, and the problem is that we don't know which is the law governing the contract, and the parties can choose a law governing the contract. And pay attention, if we are in a contract connected with Spain, Italy, and France, the parties can choose, for example, the Canadian law. No, there is no problem, or the English law. There is no problem with that. The parties are not compelled to choose the law of a country connected with the contract. They can choose the law of a country without connection of the contract. And from that moment, that law governing the contract is the law determining which are the freedom of the parties to introduce the contractors of the contract. I mean, when the parties had decided that Canadian law is the law governing the contract, the mandatory rules that limit the freedom of the parties are the Canadian mandatory rules. This is very important to understand. I mean, in international contracts, the parties have the freedom to determine the mandatory rules of the contract, because when they choose the law governing the contract, in fact, they are choosing the mandatory rules of the contract. And after this election, the parties can introduce in the contract all the contract terms they want, exception made of that contract terms that are against the mandatory rules of the law governing the contracts. This is the reason the freedom of the parties in international contract has two different parts. In the first part, the parties can choose the law governing the contract, and once they have chosen the law governing the contract, then the parties should submit themselves to the mandatory rules chosen by them in the first step. In the first step, they choose the law governing the contract, and in the second step, they introduce in the contract all the contract terms they want according with the law governing the contract. This is in truly international contracts. When we are in a domestic contract and the parties introduce a choose in favor of a law different than that law of the country in which all the elements of the contract are located, then the mandatory rules of the country that presents all the connections with the contract should be applied. The election of the parties cannot imply a derogation of the mandatory rules of that country. In a domestic country in Spain, the election of the Italian law doesn't prevent the application of the Spanish mandatory rules. In a truly international contract, the election of one law implies that the only mandatory rules that are going to be considered are the mandatory rules of the law governing the contract. In a pure domestic contract, this doesn't happen. I hope that this is clear. If it's not clear, I repeat, we can comment that tomorrow. So this is the second idea about freedom of choice. The first idea is that the parties can choose the law of any country in the world. It's not necessary that this law has connections with the contract, but it must be the law of a country. It cannot be chosen. The parties cannot choose the les mercatoria or the ASEAN law or something like that. No, the law of a country, but any country in the world. And the second idea is that, well, the second idea, in fact, connected with that is that the election can be made expressly or can be deduced of the circumstances of the case, as I have explained before. The third idea is that in pure domestic contracts, the election of a law different than the law of the country where all the elements of the contract are connected with this election doesn't prevent the application of the mandatory rules of that country where all the elements of the contract are connected with. And the last point about freedom of choice is that there is a similar situation to this in Article 3.4, where all other elements relevant to the situation at the time of the choice are located in one or more member states. The party's choice of applicable law other than that of a member state shall not prejudice the application of provisions of community law where appropriate as implemented in the member state of the forum, which cannot be derogated from by agreement. Well, what does this mean? Well, if you have understood correctly the situation of pure domestic contracts governed by the law of another country, a pure Spanish contract governed by Italian law that we have explained before, this is related with a pure European Union case in which the law governing the contract is the law of a non-member state. Imagine a contract that is connected not within a country in the member state, but with several countries, but all these countries member states of the European Union. I mean, it's a contract connected with Spain, Italy, and Portugal, for example. All of them are member states of the European Union. So, for saying that, it's a domestic contract from the point of view of the European Union. When there is a election in favor of a law of a country that is not a member state of the European Union, the election of that law, a law of a non-member state of the European Union, cannot imply the derogation of the mandatory rules of the European Union law. That means the mandatory rules of the European Union law are going to be applied in that case, and the election of the law of a non-member state cannot have as consequence that the mandatory rules of the European Union law are not going to be applied. So, in some way, it's similar to the situation of a domestic contract within a state. But in this case, it's not a contract, a domestic contract within a state, but a domestic contract within the European Union. And in that case, as in a pure domestic cases, the mandatory rules of the case in which all the elements of the contract are located, the mandatory rules of that state must be applied. In that case, in a pure European Union domestic contract, the mandatory rules of the European Union should also be applied, even in the case that the parties have decided to apply the law of a non-member state. I hope that this is also clear. Yeah, no problem? Well, if you have problems, of course, tomorrow we can discuss that. What happens when there is no when there is no election, well, we should apply other provisions in the in the wrong one regulation. The most important here is Article 4, applicable law in the absence of choice. There are another provisions about contracts of carriers, consumer contracts, individual employment contracts, insurance contracts, but now we are going to pay attention only to the rule in Article 4. That is the general rule for saying that. According with this general rule, there are specific, we find specific rules related with some kind of contracts. A contract for the sale of goods, and in that case, a contract for the sale of goods shall be governed by the law of the country where the seller has his habitual residence. A contract for the provision of services shall be governed by the law of the country where the service provider has his habitual residence, and there are another provisions. These are specific provisions. But what happens when we are not in the case of one of these provisions? Then we are going to apply Article 4.2. But first, pay attention to these specific provisions. These specific provisions prevail over Article 4.2. For example, if we have here a contract for the sale of goods, then the applicable law should be the law, as we have seen, of the country where the seller has his habitual residence. The habitual residence of the seller is the law who is going to govern the contract. And the same in the other cases we have seen. When the case is not within one of these cases, then Article 4.2. Where the contract is not covered by paragraph 1, or where the elements of the contract will be covered by more than one of points A to H or paragraph 1, the contract shall be governed by the law of the country where the party required to effect the characteristic performance of the contract has his habitual residence. So, this is the idea. The law governing the contract is the law of the habitual residence of the party who should effect the characteristic performance of the contract. And maybe you're asking, well, what's that characteristic performance of the contract mean? Well, this is a good question. It's not clear, but there are some rules to determine the characteristic performance of a contract. From the point of view of private international law, in civil law, they sometimes talk about characteristic performance of the contract, but when the specialists in civil law are talking about the characteristic performance of the contract, are talking about a different thing that we are referring in private international law when we are talking about the characteristic performance of the contract. And one of the rules, the most important rule to determine the characteristic rule of the characteristic performance of the contract, is that when in a contract there are one of the parties should make a payment and the other party no, then the characteristic performance of the contract is the performance that is not a payment. I repeat, when in the contract one of the parties should make a payment and the other party, the performance of the other party is not a payment, then the characteristic performance of the contract is the performance made by the party who is not compelled to pay. For example, in a contract for the sale of goods, the characteristic performance is the performance of the seller, because the seller is the one who provides the goods. And the buyer, the performance of the buyer is to make is the payment of the price of the goods. So, as the performance of the buyer is a payment, this is not the characteristic performance of the contract. The characteristic performance of the contract is the performance that is not a payment, for example. And there are some other rules about determining the characteristic performance of the contract. But in some cases, it's not possible to determine the characteristic performance of the contract. So when we are in a contract that is not covered by Article 4.1 and is not covered by Article 4.2, what are we going to do? So we are going to Article 4.4, where the law applicable cannot be determined pursuant to paragraphs 1 or 2. The contract shall be governed by the law of the country with which it's most closely connected. Most closely connected law. I think that we have already explained something about this kind of clauses in previous lessons. This is a final clause that at the end is giving to the court the responsibility to identify the law governing the contract without further clues. I mean, that is the same to say to the court, well, do whatever you want, or do what you think that it's better, because saying the most closely connected and giving no clues about how to determine this law that is most closely connected is saying very few. In that case, when a contract is not covered by Article 4.1, neither by Article 4.2, the court should study the case in all the circumstances, and considering all the circumstances of the case, the court should identify the most closely connected law. Probably, in some cases, it will be possible to identify this most closely connected law, probably. But at the end, there are no general rules, because you must consider each case in a specific way in order to study the characteristics and elements of the case in order to determine this most closely connected law. Most closely connected law. This is the idea of Article 4.4. So, Article 4.1, specific cases. Article 4.2, the characteristic performance of the contract, the habitual residence of the party who should affect the characteristic performance of the contract. 4.4, when it's not possible to determine the applicable law to the contract according with Articles 4.1 and 4.2, the most closely connected law. And what happens with 4.3? Well, 4.3 is an exception clause respect Articles 4.1 and 4.2, where it's clear from all the circumstances of the case that the contract is manifestly more closely connected with a country other than the indicated in paragraphs 1 or 2, the law of that other country shall apply. That means we have identified the law governing the contract according with Article 4.1 and or Article 4.2. So it was possible, the application of Article 4.1 of Article 4.2. But in the specific circumstances of the case, it's clear that the most closely connected law is not the law given by Article 4.1 of Article 4.2, but another law. This is the case of Article 4.3, the exception clause. Indeed, in that case, the court is able to, has the power to, sorry, the telephone is ringing. In that circumstances, the court is allowed to apply a different law, not the law given by Article 4.1 or 4.2, but the most closely connected law to the contract. As I have said previously, there is no possibility of giving general rules about this most closely connected law. It's not possible to do that. We have to consider the case in particular in order to determine whether there is a most closely connected law. So I think that I hope that this is also clear. If you have any doubts, tomorrow we can discuss them. As I have explained before, we have specific provisions about carriers, consumer, insurance contract, individual employment contract, but we are not going to deal with that, and we are going to move to another aspects of the Brussels, the wrong one regulation. We are going just to consider two questions, two topics before ending with article with the wrong one regulation. The first question are overriding mandatory provisions. We are moving to article 9 of the regulation. Well, we have already said something about mandatory provisions. Mandatory provisions in the sense of civil law, that provisions in a law that cannot be derogated by the parties, by the will of the parties. We have considered that when we were talking about Article 3.3 of the wrong one regulation. But now we are not talking about mandatory provisions, but overriding mandatory provisions. That is something different. In which sense? In each country, in each law, in each legal order, there are mandatory provisions, in the sense that provisions that cannot be derogated by the will of the parties, that cannot be derogated by an agreement of the parties. A part of these mandatory provisions, but only a part, are so important that are overriding mandatory provisions. That means provisions that should be applied even in international cases. So these overriding mandatory provisions are mandatory provisions that are not only that cannot only be derogated by the agreement of the parties, but at the same time, of course, they cannot be derogated by the agreement of the parties, and as they are very important, they are going to be applied even in international cases. So even in the case that there is a foreign law governing the contract, the overriding mandatory provisions of the court are going to be applied. This is Article 9.2. Nothing in this regulation shall restrict the application of the overriding mandatory provisions of the law of the forum. And in Article 9.1, there is a definition of overriding mandatory provisions. Overriding mandatory provisions are provisions the respect for which is regarded as crucial by a country for safeguarding its public interest, such as its political, social, or economic organization, to such an extent that they are applicable to any situation falling within their scope, irrespective of the law otherwise applicable to the contract under this regulation. That is, overriding mandatory provisions that are so important, so crucial is the word used in Article 9.1, that they are applied even in cases when there is a foreign law governing the contract. And these overriding mandatory provisions of the law of the forum, that means the law of the court who is giving a decision on the merits, these overriding mandatory provisions are always going to be applied. So there is a law governing the contract, according with we have seen before, but this law governing the contract should be applied jointly with the overriding mandatory provisions of the forum, of the court who is going to give the decision on the merits. This is Article 9.2 of the regulation. And then we have Article 9.3, that is about the application of overriding mandatory provisions of countries different than the law, than the country of the court. And in that case, there is also the possibility of taking into consideration these overriding mandatory provisions of other laws, but in a very restrictive way. We are not going to enter into that because I think that it could be longer than we need at this point. You should know that there are overriding mandatory provisions to know what is a mandatory overriding mandatory provisions, that the overriding mandatory provisions of the law of the foreign should be applied even in the cases that a foreign law is governing the contract, and then there is also a possibility in Article 9.3 of taking into consideration overriding mandatory provisions of a country different than the country of the court. But we are not going to enter into the details of that. And at the end, we are going to see just a point that is related with public policy of the forum, Article 21 of the Rome 1 regulation. The application of a provision of the law of any country specified by the regulation may be refused only if such application is manifestly incompatible with the public policy or public of the forum. That means that when there is a foreign law that should be applied according with Articles 3 or 4 or any other provision of the regulation, and this foreign law is against the essential values of the forum, the public policy of the forum, then this foreign law is not going to be applied. This is also important. There is an obligation of applying the foreign law called by the regulation, Article 3, Article 4, but when this foreign law is against the essential values of the forum, the public policy of the forum, this foreign law is not going to be applied. And Article 21 is the basis for this refusal of the application of a foreign law against the essential values of the forum, the public policy of the forum. Is that clear? I hope so. So, if we have, if this is clear, we have ended with regulation Rome 1. But, sorry, I have to continue with the Vienna Convention. This is the last video we are going to have. As I have explained to you, next week we are going to see insolvency in a different way, in a full class during our time at 12 o'clock with Professor José María de Dios, and I have to end with some reference to the Vienna Convention and Incoterms, because it's necessary to end in some way this part. Because till now, we have seen the conflict rules. Well, we've seen in the first moment jurisdiction, and in a second moment we have seen the conflict rules governing international contracts. But there is a very important tool in international commerce that is the Vienna Convention of 1980 on the international sale of goods, and we have to take a look at this important instrument. First of all, pay attention to what we have explained at the beginning of the first video. There is an essential uncertainty in international commerce. And this is important, as we have seen. The parties are not completely sure about the duties and obligations in a contract till the moment they are before the court. And this is because there are different jurisdictions, and each jurisdiction has different rules about determination the law governing the contract. This will be completely different in the case that we have an international commercial code. I mean, an international commercial code enforced in all the different countries in the world. This will be the situation, there will be in international level in the same situation than in a domestic level. There are no doubts about the duties and obligations of the parties, because the duties and obligations, the duties and rights, of the parties will be the duties and rights included in that international commerce code. But this international commerce code doesn't exist. There is no international commerce code, and this is the reason that we have different approaches in each country. But in some specific topics, some specific matters, and the most important of these matters is international sale of goods, there are a kind of international commercial code. And in that case is the Vienna Convention of 1980. The Vienna Convention of 1980 is not a convention about the law governing the contract. It's not a convention with conflict rules as the regulation, the wrong one regulation. The Vienna Convention is a convention with a substantial regulation, substantial rules about the duties and rights of the buyer and the seller in the international sale of goods, the consequences of the breaching of these duties, the remedies in the case of frustrating of the contract or the breaching of the duties related with the contract, and about the formation of the contract. That means the content of the Vienna Convention is the content of a commercial code on international sale of goods, but in the international field. I'll repeat, the Vienna Convention is not including conflict rules. The Vienna Convention includes rules about the formation of the contract, the duties and the rights of the parties in an international sale of goods contract. So the important point in the Vienna Convention is that when we apply the Vienna Convention, the parties don't need to know the law governing the contract, because the regime of the contract, the legal framework of the contract is the legal framework of the Vienna Convention. This is the specificity of the Vienna Convention. And from this point of view, the Vienna Convention is very helpful for the legal certainty in the international arena. When the Vienna Convention applies, then the parties have less doubts about the duties and rights they have in an international sale of contracts. I hope that this is clear. But of course, this happens when the Vienna Convention applies. And when does the Vienna Convention apply? Well, the first condition is that the court is a court in a contracting party of the Vienna Convention. Nowadays, the convention is in force in 93 countries. So there are a lot of countries in the world where the Vienna Convention applies. Important countries that don't apply the Vienna Convention: United Kingdom, India, Pakistan, Nigeria, Saudi Arabia. But of course, these are important countries. South Africa also. These are important countries. But there are a lot of very important countries in international commerce where the Vienna Convention applies. Almost all the European Union member state countries, the United States, Canada, Japan, China, Russia. So there is a lot of countries in the world, 93, and very important countries in the international commerce where the Vienna Convention applies. So when one court of one of these countries is knowing about a case related with international sale of goods, then the Vienna Convention could apply. Could apply, I am not saying applies in a applies, because there are some cases in which even in these countries that are countries contracting parties of the Vienna Convention, the convention doesn't apply. We need to know the rules governing the scope of application of the Vienna Convention. And which rules are that? Well, we have to pay attention to the Article 1 of the Vienna Convention. In Article 1 of the Vienna Convention, the first message is that the Vienna Convention applies when we are facing an international contract. This convention applies to contracts of sale of goods between parties whose places of business are in different states. That means that it's necessary that the place of business of the buyer and of the seller are in different states. The convention doesn't apply in pure domestic cases. We need that the countries of the places of business of each party are in different states. This is the first requirement for the application of the Vienna Convention. But this is the first requirement, is not the last requirement. Because the last requirement is in this Article 1A. This convention applies to contracts of sale of goods between parties whose places of business are in different states when the states are contracting states. That means the convention is going to be applied when, first, the court is a court in a contracting state of the convention. Second, the contract is an international contract. Third, the places of business of the buyer and the seller are both of them in contracting states of the convention. If the place of business of the buyer and the place of business of the seller are in contracting states of the convention, then the convention applies. But what happens when the place of business of the buyer, the place of business of the seller, or the place of business of both of them are in non-contracting states? Then, and in this case, the court that is knowing about the case should apply the conflict rules of the private international law system of the court. I mean, we are trying to apply the Vienna Convention. We have seen that it's a sale of goods, that it's an international sale of goods, but in the next step, the step of considering where are located the places of business of the buyer and the seller, we realize that one of the places of business is not in a contracting state, or neither of the places of business are in a contracting state. Then the court should apply the conflict rule, the rule determining the law governing the contract. And in that case, when the law governing the contract is the law of a contracting state of the Vienna Convention, then the court should apply the Vienna Convention, letter B of the Article 1 of the Vienna Convention. This convention applies to contracts of sale of goods between parties whose places of business are in different states when the states are contracting states, or when the rules of private international law led to the application of the law of a contracting state. That means that even in the case that the place of business of one of the parties or both parties is not in a contracting state, when the conflict rules in force in the country of the court leads to the application of the law of a contracting state of the Vienna Convention, then the Vienna Convention applies. There are two ways of applying the Vienna Convention. One of the ways is because the places of business of the buyer and the seller are located in contracting states of the Vienna Convention, and the second way to apply the Vienna Convention is that the applicable law to the contract is the law of a contracting state. I hope that this is clear. We are going to comment that tomorrow. This is very important because it's the way to determine the spatial scope of application of the convention. Then we have to check out that the convention, the contract is not within one of the cases that are excluded according with Article 2 of the Vienna Convention. This convention does not apply to sales of goods bought for personal, family, or household use unless the seller at any time before at the conclusion of the contract neither knew nor ought to have known that the goods were bought for any such use by action, on execution, or otherwise by authority of law, of stock, shares, investments, securities, negotiable instruments or money, of ships, vessels, hovercraft, of aircraft, of electricity. We are not going to enter into that. You should know that there are some exclusions of the applicability on the exclusions on the application of the Vienna Convention in Article 2 and also in Article 3 that is related with the distinction between contracts of sale of goods and certain contracts of services. Contracts for the supply of goods to be manufactured or produced are to be considered sales unless the party who orders the goods undertakes to supply a substantial part of the materials necessary for such manufacture or production. This convention does not apply to contracts in which the preponderant part of the obligation of the party who furnishes the goods consists in the supply of labor or other services. These are cases in which one party has ordered goods in a very specific way. And then the doubt is whether we are in a case of sale of goods or in a case of a contract of services. And the distinction is that when the one who ordered the goods supplies a substantial part of the materials, then the other part is not really selling, but is doing or it's affecting a performance of the provisions of services. This is the reason that this kind of contracts are excluded. But when there is an order, a very specific maybe, we are not buying a car that is in the stock, but we are saying we want a car with these characteristics, these very specific characteristics. In that case, it's still a international sale of goods. It's not an international sale of goods when the one who orders the product is also obligated to provide a substantial part of the materials used for the production of the good. This is the sense of Article 3. So you must take into consideration the scope of application in the space of the Vienna Convention and this exception in Article 2 and 3. And you should also consider Article 100, because Article 100 is about the application in time of the Vienna Convention, but we are not going to enter into now. You should know that there is an Article 100 about the application in the time of the Vienna Convention, but we are not going to enter into details about this article. Is that clear? Well, this is in very, very general terms the Vienna Convention. And now we are going to enter into the last point of this lesson about Incoterms. Incoterms. What are Incoterms? When we are talking about Incoterms, we are talking about what? Well, Incoterms are predefined contract terms for the international sale of goods. But in practice, they are very, very important. But the point is that they are contract terms. They are not law. They are not mandatory rules. They are not even the law of a country. They are contract terms. Contract terms prepared by the International Chamber of Commerce. The International Chamber of Commerce, that is a private organization working in the international commerce, studies the practice in international sale of goods and prepares contract terms, and they give these contract terms to the people in the international commerce, offer these contract terms to be incorporated in the international contracts. Well, you can ask, why are they doing that? Well, for money, of course. The International Chamber of Commerce obtains a lot of money of the Incoterms because they sell the Incoterms. It's not possible to obtain the Incoterms without paying a money for the book or the electronic publication about that. And the International Chamber of Commerce also offer courses about the Incoterms and other services, but of course they should pay to obtain these services of the International Chamber of Commerce. And the International Chamber of Commerce is formed by people acting in the commerce, and the persons and the companies who are associated to the International Chamber of Commerce pay a fee for taking part in the International Chamber of Commerce. And there is, in fact, a lot of money around the International Chamber of Commerce. And one of the works of the International Chamber of Commerce is not the only work of the International Chamber of Commerce, but one of the activities of the International Chamber of Commerce is to study the practice of the international commerce, international sale of goods, and they offer these contract terms to the parties to be used in the international contracts. Each 10 years, they modify these contract terms in order to adapt these contract terms to the practice. The last revision of the contract terms for the international sale of goods, Incoterms, is of this year, 2020. So it's very, very new, really. The previous version of the Incoterms is of 2010, as I have said, 10 years, and this is as I have said, this is a set of contract terms offered to the parties. What are you going to find in this set of contract terms? So you are going to find the regulation about the point of transferring the risk from the seller to the buyer. That is very important in international sale of goods. At what point, if there is something with the goods, the risk is to the seller or is to the buyer? At what point the risks related with the goods change from the seller to the buyer? Another point is who must underwrite the shipping contract, the organization of the obligations between the parties for logistic and administrative charges during the process of the contract. from the point that the goods are in the country of origin to the moment the goods have arrived at the country of destiny. Who should take care of the packaging, labeling, handling operations, loading, unloading the goods, and obligations of each party related with the export and import of the goods. So, in the international sale of goods, there are some obligations linked to the operation, sometimes connected with the transportation of the goods, with the administrative charge of the goods, the administrative requirements for the importation of exportation of the goods, and in order to make easier for the parties to reach an agreement in these questions, the International Chamber of Commerce offer set of contractual terms to the parties. And the parties can introduce these contract terms in the contract. But as they are contract terms, the only value of these contract terms is the value given by the parties. These contract terms are at the same level that any other contract terms in the contract. As I have said, they are not mandatory rules, they are not public law, they are only contract terms offered by a private organization to the people who works in the international commerce. And as the necessities of each party could be different, there are different sets of contract terms. And I'm giving you in the screen the different kinds of contract terms you are going to have in the Incoterms. Ex-works, free carrier, carriers paid to, carriers and insurance paid to, delivered at place unloaded, delivered duty paid, free alongside ship, free on board, cost and freight, cost, insurance and freight. And each term is giving a different distribution of tasks between the buyer and the seller. And this each party is going to take the set of rules it's more suitable for the necessities of that specific contract. We are not going to see to see into detail all this set of rules of this set of contractors. You should know that the Incoterms are different sets of contract terms covering the duties and rights of the parties, buyer and seller, in the international sale of goods. These duties and rights are connected with the task that should be fulfilled in the operation of the international sale of goods, tasks related with the carriers of the goods, the administrative charges of import and export, the shipping, labeling, packing of the goods, the loading and unloading of the goods, and these different, as there are different possible distribution of this task between the buyer and the seller, there are different sets of Incoterms, and there is a list of Incoterms. Of course, you don't need to know the list by heart. I don't only want that you have an idea about the that there are different sets of rules in the Incoterms. I hope that this is clear. And this is the end. This is a longer video than previous videos, but I wanted to end with this video, this series of videos about international commerce law, covering not only Rome 1 regulation, but also Vienna Convention and something about Incoterms. It's not now, as you know, tomorrow we are going to discuss about about international contracts, and the next week, 19 May, we are going to see insolvency. And this is all we were able to study during this course. As I have explained you at the beginning, it's not possible to cover all the program because we have only 14 weeks and there are a lot of matters in international commerce. There are some questions, arbitration, for example, that we are not going to consider, insurance contracts, we are not going to say a word about insurance contracts, and warranties in international commerce, we are not, it's not possible to cover all these issues. And as I have explained to you, at the final exam, we are only to ask about questions we have explained in class or in these videos or in the meetings through Teams. As you have access to these videos and also to the meetings through Teams, all these topics and all the topics we have dealt with in the previous classes before the end of the classes in the classroom at the middle of March. All these things we have explained could be object of questions in the final theoretical exam, but only these questions. And so, as I have said, tomorrow we are going to deal with all these questions in the meeting through Teams. And if you have any doubt, as I have said to you a lot of times, I think you have always the possibility to have a tutorial session with me. So, good afternoon.